single country should sign the convention individually. So they still have to resolve that. Now this is important. We only have 19 ratifications. The countries that are highlighted in blue are the ones which are in the Asia Pacific region. Right? So UK hasn't, so the major economies haven't ratified, so they're not parties to the convention. China, US, India, right? ASEAN, Brunei, Malaysia, Philippines have signed it, but not ratified. Thailand hasn't even signed it. So that's where we are. Japan is the most significant one, who immediately they didn't sign it in 2019, but what they did was they acceded to it, right? So they signed and ratified all at the same time, and that was last year. So not great, if you look at the economies of the world. But partly also because it was signed just before COVID, and things are picking up. So for example, we know India is looking into it. So that would be quite, UK is also looking. Okay, now so this is the Singapore Convention. Like I said, I'm not going to give you a law lecture, but very short, 13 articles. I will just highlight the main point. It's a procedure where the parties reach a settlement which they agree to, they agree with, so it's voluntary. There's a third person who's called the mediator. The most important thing is that that person, the mediator, cannot impose a solution on the parties. The parties have to come to the solution themselves. And that's the magic of the mediator. Then it comes to enforcement, which is what the convention is supposed to address. Now the interesting thing is that the enforcement comes about only in the event of a breach. It is not like you have a mediated settlement agreement and then you run to the court and you get it registered. Only if there's a breach, then the convention comes in useful. And these are the conditions, right? You run to the court of the country. So let's say if Thailand was already let's say I breach it, right? So if Thailand was already a party to the convention, everybody would just come to Singapore. The designated court in Singapore is the High Court. You come to the High Court, put in an application, produce the settlement agreement, produce evidence that the settlement agreement was achieved through mediation, you register it, you get a court order, and then you enforce the court order. So that's how it works. Similar to arbitration, there are instances where the court will not grant a relief. The usual incapacity, if it's void, if it's illegal, if one party says that part of the agreement has already partially performed, the usual terms. This is significant to note. The court will not grant the order if there's any indication that the mediator has reached mediation standards, professional standards, and ethics. What are mediation ethical standards and mediation international standards? That is the difficulty with mediation. You have to set it up yourself, right? So Singapore has a body. This is something that Thailand will have to look into if you want to ratify the convention. The thing is that there are reservations to the convention because this is an international treaty. So you can sign the convention like Belarus and Brazil, but say that the convention doesn't apply if the government agency is a party. You can also sign the convention and say that I signed the convention, but the parties to the dispute have to agree that the convention is signed. So it becomes very untidy because if you look at this table, there are 4 categories of countries. Some have signed the reservation to A, some have signed the reservation to A and B, some have signed it to B, some have said, okay, I take the convention as a whole. And then we have Iran, which had a reservation which wasn't worded in A and B, so we don't know what they actually made a reservation to, so it's not counted as the signatories. Pakistan has signed, but they have made a reservation to A and B. Now this is Singapore's journey. The courts started mediation in the mid-90s. The mediation center started in 1997, but that was only for domestic mediations. Nothing happened until 2014. son, a child that gone from primary school and graduated in university already, So what happened was that there was a Chief Justice who in 2012 said, okay, we have to do something. And suddenly, it happened. We set up the International Mediation Center to deal with international commercial disputes. We have SIMI, which is the standards body, which accredits mediators. Then we have CIDRA. So all this happened in 2014. We had our Singapore Mediation Act for domestic mediations in 2017, Singapore Convention 2019. As I said earlier, we brought the Singapore Convention into Singapore 2020 and became law. So that is what that is Singapore's journey. There was initial resistance, of course, as with everything. I think lawyers, we are brought up to resist change because we are brought up on the concept of precedent. But, in Singapore, we're very obedient, The court said do it, and the government said get it done. So, there was leadership, from the courts and the government, in our case, the Ministry of Law. And I think the view of it, the view of it was that mediation was viewed as a necessary legal service because Singapore was we were positioning ourselves as a global financial center. I won't go into the advantages of mediation, I leave it to talk about. And what has happened is that in the years since the convention, the last 5 years, traditional legal businesses were not affected. So all of you there who are litigators, who are arbitrators, you will still carry on with your arbitration. You can still carry on with going to court. Right? The courts are still relevant. In any case, you need the courts to enforce the order. Right? And there are some cases which need to go to court because you want to change the law. For example, it helps in wealth creation because mediation becomes a new tool in your toolbox which you can use to advise your client to consider if the nature of the dispute, if it's the best option, right, given the nature of the dispute. The Singapore Convention has created a new way of obtaining a court order. You go and mediate, you can get a court order. You don't have to go to arbitration to get a court order, you have to go to court to get a court order. And this international mediated settlement agreement now becomes a new type of internationally recognized legal instrument. And I think from the investor's point of view, or from the businessman's point of view, it's good for them to come into Thailand if they are a member of the convention, signatory to the convention, because they know that this is available. We know the advantage of mediation is cost effective, as the previous panel mentioned. It saves time. We can mount the mediation. SAGE has mounted the mediation in 2 days. But for international mediation, you can easily mount it within a month, if not 2 weeks, if everything is ready. Mediator is neutral. Parties agree to the final settlement, which means that enforcement, in the last 5 years, right, enforcement is rarely used. And that's why you want to search for case law, or what is the law on this mediated settlement agreement. Very little. Because in a well-mediated settlement agreement, the parties have agreed to the settlement, and they will do it if they sign in good faith. What is happening now in Singapore? There's recognition that if you go to a mediation, you cannot think like a lawyer. You have to think like a mediation advocate. And many of the major law firms have set up mediation departments. And they have sent their lawyers for training to be trained as a mediation advocate. There are more mediation advocates now. And there's a development of performance indicators, or whether, just like, you want to know whether this person is a good litigator or this person is a good corporate lawyer. There's an awareness now that you need to recognize whether this person is a good mediation advocate. There's an awareness that you need standards. And people also realize that you need to be able to know who is a good mediator, and you need to choose a mediation advocate, you need to know and keep up to date on which country has signed and ratified the Singapore Convention. Otherwise it doesn't work. You need to advise your client, right, on the choice of mediator and where do you want to take your mediation. Do you want to mediate it in the Singapore International Mediation Center, which is a government agency, or do you want to mediate it at SAGE, which is a private mediation service provider? There are pros and cons. You need to be able to advise your client on whether to use the Mediation Act or use the Singapore Convention. You need to be very culturally sensitive to cultural differences. And also be aware of what the professional ethical rules for mediators are, because otherwise the mediation settlement agreement can be set aside. And so you can see it's a whole new area of skill and knowledge which need to be trained. This is the last slide. For those of you who are still worried and asking questions about, so what about the rule of law in go for mediation? Where's the access to justice? Now, the courts, and not just the Singapore Chief Justice, but CJ Menon is the one who pushed through the mediation in Singapore. You know, if you talk about access to justice or you talk about justice, what is justice? Justice, everybody says, I want it to be fair. What is more fair than an agreement which the parties have signed? It becomes fair not just to one party, but it becomes fair to both parties. So therein lies your justice. So what CJ Menon said was that even though mediation takes place outside the traditional court system, okay, we are still serving justice. And he believed, way back in 2021, that mediation was fast gaining momentum, and particularly for Asia. Right? We know that Asia Pacific is the next area of growth in the whole world, if not already. And there's a rise of big corporations in Asia. And we all know that all of our Asian cultures have a tradition of resolving disputes amicably, village elders and all that, right? And therefore, he really believed that we are on the cusp of mediations globally. So there we are. Thank you very much.
Thank you very much for your presentation that gives like overview of the Singapore Convention and also the Singapore journey starting from resistance up until today, where you have like a system to facilitate, mediation. So and also answer me like why it's called Singapore Convention. Thank you very much. So now moving on to Amy. As per your extensive experience in Thai legal framework and also Japan's practice, can you please share with us if Thailand is ready for the Singapore Convention? And also, as Judge Jane mentioned that Japan ratified but with conditions. So please, can you share with us on that?
Yes, thank you very much. Thank you to THAC for the invitation today. I'm very excited about this panel and this discussion because I do think that Thailand ratifying the Singapore Convention is really quite a positive way forward if that is the direction that it wants to move in, and really quite a practical solution, I think, in terms of resolving disputes for cross-border transactions. And I'll go into that in a bit more detail in my presentation. And there are two main issues I want to address. One is Thailand ready for the Singapore Convention? And the short answer is yes, but I'll explain why. And the second issue is insights from Japan's experience. Now, we heard from the panel earlier about the reforms being made in Japan, and it was very informative to see how far Japan has come in terms of its reforms for arbitration. And they also touched upon the mediation reforms as well, which is what I'll be talking about a little later in my presentation. So I won't go into much detail with the background because Judge Jane has helpfully explained to us the definition of mediation and Singapore Convention on Mediation, the background and history. And also I think the key point to remember here is that the Singapore Convention is a framework for the enforcement of international mediated settlement agreements, or IMSA, as Judge Zhang mentioned. I think it's important to remember that what the Singapore Convention does is it fills a gap. Because previously with arbitration, and it's currently in force, of course, is New York Convention, and everybody is quite familiar with how the New York Convention really put arbitration on the global map, because it's enforceable in all the countries that are signatories to the New York Convention. There was a gap for mediation, because mediation agreements were not easily enforceable in jurisdictions. The Singapore Convention fills that gap. And as Judge Zhang mentioned, there are some key differences between the New York Convention and the Singapore Convention. And the main difference is that the grounds for refusal or to set aside the mediation agreement is different in that in the Singapore Convention there are two additional grounds. So one of them is serious breach by the mediator, and the second is failure by the mediator to disclose any conflicts. So there are differences, but the Singapore Convention fills the gap. Now, why does it matter? As mentioned, enforceability. That is really key. So now settlement agreements will be directly enforceable in states that have ratified the convention. It also gives certainty because it reduces the risk of non-compliance by counterparties. So before the Singapore Convention, if a party breached the settlement agreement, then you had to initiate proceedings afresh in court. And that will take a lot of time, and it's unpredictable what the outcome would be. But the Singapore Convention gives certainty. And finally, efficiency. It's faster, cheaper alternative to arbitration and litigation. So that should be a big plus for businesses. Now, is Thailand ready? As I mentioned, the answer is yes, and this is the reason why. Now, I'm not an economist, I'm a lawyer, but this slide sort of summarizes what Thai business and economic outlook is for 2025. And as you can see, the graph is quite positive in terms of the trajectory of Thailand's GDP. And there's a lot of talk about how there will be growth in the future with tourism and private consumption. And also there are a lot of government stimuluses, as many of you will be aware. Now, there are challenges, of course, especially with the import tariffs from the US, and there is also a high household debt in Thailand. But generally speaking, with the tourism picking up and private consumption picking up, we're looking at quite a positive outlook for Thailand. And here are the sort of top 5 foreign investors by country. You can see Japan. We've been talking a lot about insights from Japan, but Japan is number 1 foreign direct investment into Thailand still, and it has been for decades. Now, of course, that's followed by US, and US and Thailand have historically had a very good relationship, and China, which is not surprising, especially in the automotive sector, and then followed by Singapore and Hong Kong. So you can see that there are, foreign direct investment into Thailand is still very active, particularly from Japan. And again, many of you will know that the BOI, the Board of Investment in Thailand, have many incentives for foreign direct investment. So there are tax incentives as well as non-tax incentives. I won't go into those details, but the point I want to make here is, people are going to be entering into cross-border transactions with Thai companies and foreign companies, particularly Japan, US, China. And when we are looking at cross-border transactions, it's inevitable that we need to start thinking about how will we resolve any potential disputes from those transactions. And mediation would be a tool, as Judge Sheng said, another tool in the toolkit that investors can consider. Now, I won't go too much into this slide because my colleague here, Kun Pat, will go into details of the current ecosystem of mediation in Thailand. But many of you may be familiar that in Thailand there's court annexed mediation. So that's pre-litigation as well as post-litigation in this court litigation context. But there is also out-of-court mediation, which is governed by the Mediation Act of 2019, as well as private mediation. So there is certainly potential for growth of mediation in Thailand. There's an upward trend of foreign investments, as you saw from the previous slide. That will mean more cross-border transactions, and then potentially in the future, more cross-border disputes. There's a growing interest in mediation. Now, mediation is not new to Thai parties, as we saw from the previous slide. Parties are very familiar with mediation in the court context, and also out of court. So it's not a new concept in Thailand. But there's a growing interest now with Japan ratifying the Singapore Convention and other countries in the region, India looking into it as well. The factors that make it interesting is the ease of enforcement, and it resolves disputes quickly and discreetly, and very importantly, cheaply. And it also preserves business relationships. Now in Thailand, as well as in Japan, preserving business relationship is a key factor. In both jurisdictions, generally speaking, they're known to be non-litigious in nature. So people don't want to go to court. They don't choose to go to court. If they can, they'll just try to settle amicably. So we have an attractive option both for Japanese parties and Thai parties because it preserves business relationships. If anybody is interested in learning more about the potential implications of Thailand ratifying the Singapore Convention, I've written an article on this particular topic together with Nikki from the THAC and Aloysius Go from Sage Mediation. So if you're interested, please scan this QR code and get a copy of the article. So moving on to insights from Japan. As you heard earlier, Japan has historically been more reliant on litigation, and more recently, in the last sort of 5 to 10 years, looking into arbitration for resolving cross-border disputes. International mediation was historically underutilized in Japan. However, in 2023, Japan ratified the Singapore Convention. So it joined key global economies. And this became effective in 2024. So this is very recent. It only was ratified, it became in force in 2024. Now, as Judge Sheng mentioned, it was with reservation. So the reservation was under Article 8, Paragraph 1B of the Singapore Convention. And it essentially is a reservation that unless the parties agree, then it will not be applied. So that was the reservation that Japan made. Now, Japan was only the 12th state to ratify the Singapore Convention, but it was the largest economy to do so. So it really was a key development in the region. And it shows that Japan is growing in its acceptance of international mediation. Now, following this, there were a number of reforms that took place. So one of them is the implementation of the Singapore Convention into the Act in Japan. And that came into force in April 2024. So that made amendments that required parties to submit their settlement agreement and other documents that evidence the agreement was a result of mediation into the courts. The other key reform was that the JCAA, that's the Japan Commercial Arbitration Association, amended its mediation rules in April 2024 as well. And that's to make it the agreements enforceable under Singapore Convention. So it has to be signed by both parties, it has to be signed by the mediator. So the procedural requirements were incorporated into the commercial mediation rules. In Japan, so the mediation rules also provided that just like the arbitration reform, there are specialized courts which can enforce the settlement agreements. So those are the Tokyo and Osaka district courts. They have been earmarked to be the courts to enforce the settlement agreements. So how does this have an impact on Japanese businesses? Well, it certainly attracts foreign investment into Japan. We mentioned earlier the importance of certainty. So ratifying the Singapore Convention has given the foreign investors more certainty in entering into these agreements with Japanese parties. It gives greater confidence in mediation for the overseas disputes. Again, another tool in the toolkit. So they can now consider litigation, they can consider arbitration, and they can consider mediation. It saves costs because mediations tend to be a lot quicker than arbitration or litigation. It preserves relationships, and it also gives a strategic advantage in cross-border negotiations. And also, even beyond businesses, we need to think about how this has had an impact on the Japanese ADR scene. And what I mean by that is, what is Japan's ADR reputation now? Now that they've ratified the Singapore Convention, it shows to the world that Japan is more arbitration and mediation friendly. It also shows its competitiveness to other jurisdictions in the region, such as Singapore and Hong Kong. And also, because they've now got specialized courts that deal with enforcement of settlement agreement, it will start to build knowledge and experience in this particular area. So I think to conclude, I mean, how is this relevant for Thailand? Well, I think Thailand is in a really good position now because it now has Japan to look to as an example. And both Japan and Thailand have a lot of things in common. As I mentioned earlier, in terms of its experience with mediation in the courts, they're already very familiar with mediation. Generally speaking, Japan and Thailand are non-litigious in that they don't prefer to go to the courts as soon as there's a dispute. They prefer to resolve disputes amicably. So mediation is a good option there as well. They're both civil law countries, so they have that in common. So looking at Japan's example, if Thailand were to ratify the Singapore Convention, it could do so similar to Japan, maybe by way of reservation, because if you enter the Singapore Convention or ratify it with a reservation, then you can gradually adopt the Singapore Convention. You don't have to go full in completely if you're not sure how it's going to turn out. So you can do it by reservation, so the parties have to expressly agree. But in the meantime, Thailand can then build up its international mediation expertise and train and educate both the judiciary, who will be enforcing the agreements, but also the legal practitioners to build up mediation advocates, as Judge Leg mentioned, because the skill set for lawyers who are mediating and lawyers who are litigating or arbitrating are quite different. And so, Thailand can consider these options in thinking about ratifying the Singapore Convention. So I think I'll stop there, but if you have any questions, please do ask.
Thank you very much, Amy. That is very good insights from your experience and also Japan's experience from you. So now let's Kun Patsawat discuss about Thailand's legal framework about mediation, and also from your extensive experience, maybe you can share with us the mediation framework in Thailand.
Thank you very much, honorable guests, and thank you, Ms. Rusha, for the kind introduction. So thank you to the SAC for organizing this event. So for myself, I'm a partner at the Global Secretary. So we are the leading the law firm in Thailand. So after we have been for like the mediations and everything, I just would like to give you like the more focus on Thailand. So I just would like to give like the overview landscape of the dispute resolution in Thailand first, so you know like the options that we have, and then I will lead my discussion into like the mediations as per the topic that we have today. So in Thailand, just to give an overview that, as you know that actually I would like to divide them like the landscape here in Thailand into like the 4 categories, like the key ones. The first one that when there is a dispute, you know that there will be the pre-litigation state. That is like the state that before, when once we know that there's a potential conflict when the dispute happen, that is where you have to prepare for yourself, and that is where when you engage a lawyer, then you are thinking for like the leverage. Yeah, because like the pre-litigation state, you perform like assault and shield. I mean, it means that it can give some leverage over the other party. Shield, this means that the other party will know that you are prepared if there is a dispute. This leverage is going to be really critical for the dispute resolution or including as well. For the second option is the negotiation and mediation, which we will go into much detail about this. And then is the arbitration, that if we have like the arbitration agreement and the litigation in court. I would say that among these 4 options that we already have when we have like this bill here, the negotiation and the mediation is a very important, functions and really critical option that all the business sector should consider about this option, because it is the only option that can provide all parties a win-win situation. When you go to the arbitration or to the Thai court, you will never get the win-win situation. They're gonna be like the party that win, the party that lost. Yeah. So the only option that will lead both sides to satisfy with the result is gonna be the negotiations or the mediations. But that's what we all know, that when we have a conflict, sometimes it is difficult to discuss with each other. Like you think that have like a husband and a wife, girlfriend, boyfriend, you have this bill. Sometimes it's not that simple, right? When you have to discuss this thing. That is quite similar when we talk about like, commercial dispute. So sometimes the mediations play like a significant role when you have a third party to help to mediate like dispute. Most of the time when we talk about mediations, when I just first begin my discussion with the leverage, already normally they would like to get like the best result for themselves. But with leverage, this is gonna be one tool that lead both parties to get the win situation later on. So that's why that every party needs leverage in order to make the result come to be like the most fairest result for all parties. So I would like to continue deep down into the Thailand mediation framework. So like what Amy mentioned before, that we have like the mediation in court and we have the mediation out of court. So these are like the key set of laws and regulations in Thailand that you need to know. So for the mediation in court, we have the single procedure code that we have just recently amended to include like the particular section that is about the mediations in court. And then we also have the regulation of the President of Supreme Court on Regulation 2011. And then we have other procedural acts. Normally if you go to the court in Thailand, one of like the major court is the civil court, right? So you think about the civil procedure court, but when you go to like the other specialized court, those courts will have their own set of rules, but they will also refer back to the civil procedure court as well. So these are all together the rules as I mentioned about the mediation in court. For the out of court mediations, we have the Distribution Act 2019. That is one thing that is like the evidence that Thailand support mediation. Because the functions of the Distribution Act actually is quite similar to the Singapore Convention on Mediation, but it's focused on the different target and different objectives. But the mechanism is quite the same. It's an act that allows the settlement agreement to be enforced by the court as well. And then we have a rule of the institution mediation, like THAC also offer like a major venue for the mediation, so THAC can help mediate the dispute as well. So we THAC have like all set of like all the convenience and agreement rules and like the list of mediator to assist. And also we can have an ad hoc private mediation as well that normally happen in very significant and complex dispute where the secrecy or the confidentiality is very important. Sometimes when we talk about like really complicated or high net worth dispute, we sometimes use ad hoc private mediations, and we also invite like honorable person in Thailand to assist in mediation. So for the out of court mediation, there are going to be the rules that depends on like apart from the Distribution Act 2019, there's the rules the institutions, and we have like the rules of that we can refer to because it's quite flexible. So mediation in court normally happen in the trunk room sometimes, or sometimes the court can refer to the mediation center that is in the court. And for the out of court mediation, I think it's quite flexible. It depends on the party decision actually. Okay, this actually is not the most updated statistics, but it can be seen. This is like the most updated statistics as published online. It's from the in-court mediations, and it can be seen that the success rate is quite high. Actually, if we look only to the agreement red color, you can see that the cases that went through like all the mediation process in court, actually like 88% were successful. Okay, so I think around the discussion that we will have today, it's going to be surrounding about the strength of the Thai mediation framework, because that's going to show us the need or like the reason why that we should join the Singapore Convention on Mediation. What is like the thing that we can enhance our judicial system, and limitation of Thai mediation framework, and also the implications for Thailand, and also the challenges. So this is like the key one. I would say that the strength of the Thai mediation framework right now is that, first of all, it is familiar to Thai lawyer and also to Thai court, because we have working on like the mediations for a long time. We even have like a specific law on mediations, and then it's a cost and time efficient because it can be settled, and the party do not need to go into like the full trial process. It's flexible, but it is dependent on the forum as well, and it's provide a mutual benefit for the party dispute. But still, there are like the limitations on the Thai mediation framework as well. The first of all is that the agreements that happen, normally it would serve as like one agreement, and it's not directly enforceable in foreign jurisdiction without having like going to like the international convention. That is really similar to the New York Conventions, that okay, once we are the party to the New York Conventions, we can enforce over elsewhere. It's similar to the mediation as well, the same agreement. And then, for the mediator, I would say that is still unclear standard right now in Thailand, because it depends a lot on the forum that you choose. sometimes you might want to have the mediator who have an expertise on the dispute in order for them to understand more, understand better the need or like the issue of concern of the party. But in some forum, you don't have that flexibility or you don't have that option. Yeah, and because the standards are not clear in Thailand yet. And then I would say that the judicial mediation still dominates right now in Thailand. So sometimes when we talk about the international commercial dispute, party dispute that is like the foreign party, they may want or expect to see like the mediation that not take place in the trial room, for example. So when we talk about the practice, I'm come from the background of like the practitioner, so I do a lot of cases as also involved in one of the landmark cases in the mediation as well in the civil court. And I would say that when we talk about the mediations or the negotiation, some people might think that this is like the venue for the party dispute, and maybe the lawyer may have fewer roles in this, but I would say that is untrue. I mean that actually for the mediation process, I think that we will discuss later on the panel discussion. So I would focus on the role of the maybe general counsel first. So for general counsels, when you participate in the dispute, the mediation process, you have to think about what is the benefit of the mediation and settlement, because I would say that I actually have recently just have a case that I may need to pursue like the arbitration dispute in Singapore, and I would say that the cost of time is not less. It depends on if you use like a big law firm, major law firm, maybe the cost for the arbitration can be ranged from like 1 to 3 million USD. That is like the cost for the whole process, and also the time for the arbitration for the high complex case. It can be ranged from like 6 months to 18 months. So actually, these times might consider like excessive, for some of the users and for the opportunity that lost. So as a general counsel, you can see the benefit of the settlement and the mediation that it could make it much faster and less costly for the company. And then it's going to lead both parties to the win-win situation. And that's why this have to be taken into account when the company have to decide whether it's going to go into the mediation or not. And also, one of the key issues that company need to think about is whether when you go to the arbitration or to the court, it creates precedent. It creates precedent for the company. Sometimes you don't want precedent, based on this bill, because you really like the commercial basis. Yeah. But when you need a lawyer, it means that in this process, it means that you need an impossible contract. So that is the very critical, function of the lawyer here. If you want to get an award, the award is arbitral award is going to be impossible if like the procedure is correct, and it's an issue about that we all know the New York Convention, and the arbitrator also have to play like a key role here. But for the mediation, actually, it is a lawyer. It's a lawyer who have to be making sure that the contract is clear enough. It's impossible. Yeah. At the end of the day, because that is like the shield, the protection that everybody would like to have. For the implication that Thailand, I think that Judge Cheng and Kunapi has mentioned about the implication for other countries before like the benefits and everything. So I think that applies similar to Thailand. Thailand joined the Singapore Conventions on Mediation. I'm certain that this going to be strengthened the confidence in the foreign investor doing the business in Thailand, and then also that for the business sector, then it's going to be they're going to have another way, another tools for resolving this dispute. And once you have a confidence in resolving the dispute. You are confident that you're going to have the settlement agreement that can be enforceable. It means that you have a confidence to invest. That is really important because otherwise you will never know that your investment, when there is a dispute, you're going to recover it or not. Yeah. And for the government, it's play a crucial role in the ratifications and standard setting and also policy building. I would like to, recap just a bit here that I like what the managing director of the THAC mentioned earlier at the beginning before. Mr. Suryapong mentioned that justice delay is just denied, and I also heard some the point of issue about from the audience that we need an affordable dispute resolution. We need an affordable justice. I would say that settlement agreement by the mediation serve these two purposes. It serves the time that we use to resolve the dispute, and it also make the justice affordable. And it is the only option that make the win-win situation for both parties. So I think that when we see this clear advantage of the mediations, it means the future. It's the future that you can see the trend everything that we lead to the trend that we want to have the thing that serve the people concerned, and this is the option, the tools that serve the people concerned. Yeah. Later on in the discussion, I will also would like to propose some very creative and challenging proposal that to the policymaker that maybe if Thailand would like to be like the country that really promote the ADR, arbitration and mediation, maybe we need to consider like the lesson from Japan. That we may think about of having the specialized court, like arbitration and mediation court in Thailand. That can show like a clear signal that the government Thailand support the ADR in Thailand, and that can create like a unified system in Thailand, and that can promote investment a lot much more. So I'm going to park my part here. Yeah, because this next solution.
Thank you very much, Khun Pasawat, for sharing, the recent updates on the mediation in Thailand, and also his view from practicing in this area for a long time. So that's very good insight. So now we have some time for the panel discussion. So let's talk with our panelists. As we heard from Khun Pasawat that the statistics of the mediation in Thailand shows that Thailand, Thai people, Thai parties are very familiar with mediation. This is something in our nature, in our culture, and also which Judge Deng mentioned earlier that according to Sidra, to get the justice, we need certainty, enforceability, efficiency. So with this combination, in couple with Khun Emmy, statistic report shows that the 2025 GDP growth and also the upward trend of investments and also cross-border disputes. So these factors seems like Thailand should be ready for signing or joining the convention, especially when Khun Pasawat said that the limitation in the mediation framework in Thailand is that we lacking the clear enforcement if the parties settle, because it cannot be enforced in overseas, in other jurisdictions. And also we do not yet have like the mediator standard. So I would like to hear from the panelists here that what could be the reason that hold Thailand from joining the convention? And with such uncertainty, like that they don't feel ready to join convention, what would be the options for them? Should we follow the Japan model with reservation model, or should we join like Singapore, adopt the full ratification and everything? So maybe I hear from Khun Amy.
terms of the first question you had, what would the reservations be? I think we just have to go back to what Judge Jen commented on earlier, which is, as lawyers, we don't like change. And actually, I don't think that's limited to lawyers. I think it's for most of us, right? I mean, change is unpredictable. There's a lot of work that has to go into transitions and change. However, I think that, well, I hope that our presentations have persuaded many of you that there are quite a lot of advantages in considering signing and then ratifying the convention. And of course, we don't have to go all in if we are not sure about these changes. We can adopt the reservation model as Japan has and see how we go. Because I think it's about taking small steps. And if we are not so sure about change, we can certainly take small steps to begin the change. But the advantages of Thailand doing this is really quite enormous in that it will really put itself on the global map of becoming a hub for ADR within this region. We saw from the statistics that Judge Jen shared that apart from Japan, I think Sri Lanka were also ratified, but there really aren't many countries in the ASEAN region that has ratified this Singapore Convention. So by Thailand considering doing this, I think it will really send a strong signal.
Kun Pasawat, do you have any?
Yes, I can put out to the information a bit. I think that actually Thailand, we are quite ready. I would say we are very much ready actually because like what I mentioned earlier, we have the Thai Distribution Act 2019. I think that we provide quite like the framework and the basics that make we are ready for joining the SCM, not too difficult. But I mean, in terms of the ecosystem, it's like a different issue. For the ecosystem, like the forum and the court and the lawyers here. I would say that the Japan model is one of the very interesting options that we can consider. But for the capacity building, we should. I think in the past we have promoted quite a lot in the arbitration. Yeah, but for the Singapore Convention on Arbitration, I would say that maybe for this forum, maybe like the very first forum I think this year that we specifically mentioned about the Singapore Convention on Arbitration, we should create more awareness and make the lawyer and the practitioner because they're going to take a key role in drafting the contract. Yeah, and also this will going to encourage the government in order to ensure that the lawyers in Thailand are ready for this. Yeah, so I think that to me, I think that the gradual approach will serve better for Thailand. Yeah, because like the ecosystem and for the lawyer that okay, we should have more awareness on this. Yeah, but it's going to be in the future that I think that like what I mentioned that it can boost much confidence in this investment in Thailand.
Go back to my presentation, please, and you look at slide 13. While you do that, let me just say that, if you want to do something, there are two ways of going about it. Either you plan and make sure everything is in place, and then you ratify the convention. And this is very Singapore. We must plan, everything is ready, okay, we'll do it. Or you could do it the other way, like what Emmy was saying, ratify first with the reservation, and then so that you create the confidence for the businesses, right? Then you sort of put the pieces into place. So I'd just like to show you what are the pieces that you need to put in place, and then after that, with your familiarity with the situation in Thailand, you can see where you are. Now, So look at 1997, we set up the mediation center. Why? Because we needed to train the mediators. But the mediation was only going on in the courts. Commercial mediation didn't really take off. So by the time we came to I actually took my mediation accreditation course in 1999 when I was one of the first lecturers, right? Then I passed. But no cases to mediate. So in the meantime, we had this whole bunch of mediators who were being trained by the SMC, but no mediation cases. Then the courts got into the act because Chief Justice Menon said, let's get on with it. So 2012 it started. Right? But you see, 2012, because that was when the negotiations for the Singapore Convention were already taking place. So we knew that we were going to ratify it, and all this work was going on in the background. So what do you need to have a mature mediation ecosystem? As I said, the stars, I always say the stars need to be aligned. One, you need government support because you need the infrastructure. Ask Ministry of Law for you, I think it's your Ministry of Justice. You need the courts to buy in because if you want a flow of cases to mediate, it's going to come from the courts. And courts will use it because, as was said, it loosens and it relieves the backlog. Sri Lanka had it. Myanmar, before it fell apart, they were already sending judges to Singapore to study the system. Sri Lanka is into it. Now, Sri Lanka is very interesting because they ratified the convention first, and then only now they're talking about the Mediation Act in Sri Lanka. But Sri Lanka's backlog was 20 years. So courts need to buy in, and it's a very useful. If the courts do it, people usually follow it. Because then the parties will get used to experiencing mediation, the lawyers will be forced to actually learn about mediation. Where else do you need to get the buy-in from? Universities are important because when they teach the law students, right, in law school already, the law students will know that if I have a dispute, mediation is an option. So when they come out into practice, they are already prepared to advise the client. Bar association has to have the buy-in because you have to convince the arbitrators, you have to convince the litigators, right? So the lawyers have to have the buy-in. So what happened in Sri Lanka was when they had the convention, right? Ratified the convention easy because at government level. But when they introduced the Mediation Act to have mediation in Sri Lanka, there wasn't sufficient consultation with the Bar Association. So big pushback. So you need to have the buy-in from the lawyers. Right? And then you need to have the buy-in from the parties themselves. They have to experience mediation to realize that if I take my case to mediation, I am not saying that I have a weaker case. Sometimes, the party who has the stronger case wants to go for mediation because you go in and you have a stronger negotiating power. You take the strongest stand. So, once the stars are aligned, it will take off. And that's why you see 2014, everything happened. And then it was the Singapore Convention, and then we got to it. So it's a long journey. I mean, you take a look at it, it's how many years? 2014 to 2019, I think. Oh, actually not so long. But for it to actually take root, and now people know it's mediation, not meditation. You know, it's 10 years. It's a long time. So that's my contribution for my observations about it.
Thank you. So it seems to me that Singapore is apparent to everyone here that Singapore has taken time to prepare themselves first before joining the Singapore Convention. So like Thailand, so we should be, if we want to join the Singapore Convention, we should start preparing ourselves. So please let me ask the panel, like what we need to prepare from your experience and from your view on this, like the clauses, the training to the lawyers, or how should we like start with the preparing?
I would say that every sector need to help each other, because I think we all do agree here that it the bargain, you know. So for a lawyer, let me, if you are a lawyer in this room, let me imagine that because as a lawyer, you work based on fact, right? If you know that the fact is not good for your client, your client is in a disadvantaged position, what would you want? You know the result of the case that it can be negative. You really want to have a win-win situation for both parties. That's where the arbitration comes. If you like the business sector, when you have a case, what you need to think? You need to think about the body of proof. You need to think about the compiling excessive evidence to prove. For example, opportunity loss. How can you prove the opportunity loss for business? That is like the hard work. What do you think about the future? And that is the mediation, right? So, I mean, if all sectors understand the benefit of the mediations and in terms of like the international commercial dispute, that's why when we do like the cross-border business, because we want more today because we are like conversation, right? What it is like the certainty, and that is where the Singapore Convention on Mediation have, you know, like the New York Convention, we need certainty. So I mean, if the sector understand the, surrounding environmental benefits of this, then I think that every sector should, perform their own function in order to promote the use of the Singapore Commission of Mediations, and we have like the approach that what Amy mentioned, and also like what the Japan take. That is like the option that we can reserve ourselves, enjoy reserve, right? Yeah, and then if you think about this, quite into more details. Actually, it's quite pretty similar to the New York Convention. Actually, the court still play, have like some still have like the power of the sovereigns, and also to retain the power to oversee the dispute. So actually, it's quite the same. But the benefit of the mediation is like promote investment, promote confidence, promote another tools for the business, and create more job for the lawyer as well, because you have more role to play and you have more time. Yeah. So I think that in a nutshell, I think that if every sector understands the benefit, then all the function that they perform, they should be to like supporting the use of like the mediations, and also the benefits of joining the international convention in the scope of the investment.
I agree with Kun Pasawat because I'm a Thai qualified lawyer as well, and I really hope to have a useful tool like Singapore Convention to support our clients when they do not want to go for the award, for the disputes, and eventually get the award or the decision that they do not agree with. And also sometimes, as Kun Pasawat said, that it has to be published in public, when it's gone up to the Supreme Court and it creates a precedent case. That is something that for the Thai group of companies maybe like to avoid, because they don't want to have precedent case and then the parties would come to them and try to follow the precedent case, which would cause more business disruption for them. So that's why I agree with Kun Pasawat and everyone here that the Singapore Convention would be a useful tool for us as the lawyers and also for the Thai clients as well.
So can I just add, please, Sarja? I think in terms of preparation, we've covered, how lawyers need to prepare. We need to start normalizing this idea of mediation as another tool for dispute resolution in addition to litigation and arbitration. But I really do think also that it's about a change in mindset of how we perceive mediation. I think Judge Zhang touched upon this as well, but mediation should not be seen as the weaker option of the three. And as Kun Pap mentioned a few times, it's really quite a practical solution and often leads to a win-win situation for our clients. And if you are practitioners in this room, you know, a happy client is always a good thing, right? So if you can secure a win-win solution for your clients through mediation, then that will eventually lead to potentially more work for us as well. So I think it's changing the mindset both for ourselves as practitioners, but also for our clients, that, you know, mediation is not a weak option. Actually, you can, you know, you need to think about what is the definition of success. You know, for your client, is that really having their day in court or before a tribunal and getting a win, or is it about, you know, finding a solution quickly and getting on with their business, right? So I think it's about redefining success as well for our clients. So a shift in mindset, I think, would be quite helpful in this context.
Thank you very much. So we now have 2 minutes left. Yes.
Thomas Wong from Lawyers Council and Liverpool Partners, representative of Foreign Affairs Committee. Firstly, may I say ratify first? Yes, I do agree with this. Whatsoever, ratify first. If you don't ratify, nothing gonna happen, right? I do agree with this. So Singapore model is quite very successful. We appreciate from Japan. Japan is, wow. There's a life learned lesson learned and something like that. That is, we learn by the obstacles. And now I feel like we are having the obstacles in Thailand right now. There's no one say, hey, we wait there, wait for preparing what? Ratify first. Who agree with me, Thailand should ratify first? Please give ourselves a big round of applause to support this. Thank you. Ratify first. Why we wait so long? It's now or never. Like Elvis Presley speaking. So I do support about to ratify first. Seem like in Sri Lanka, right? Yeah, we should start first. I used to have a case, international trade dispute, to intellectual property international case. That's dispute. There's the court case. Even what is said that in the contract. The contract, there's a terms and conditions. So of course we have those specific terms, and in general terms and conditions. One clause is for arbitration. It's exactly written before bringing the case to the Court of Justice. It's primarily go to what? Arbitration first. And then we didn't follow that. But the court accepted the case for trial. Even in the contract, written exactly in the course, before we bring the case to the Court of Justice or intellectual property or courts, we should go to arbitration first. But this never happened in Thailand. And the court just ignored this. If other party say that, hey, why are you bringing the case to the courts? It's written clearly, we should go to arbitration first. But we didn't do that. So right now we're feeling like we can't wait so long. Thailand right now, so Lawyers Council in Thailand, in Thailand we have about 100,000 lawyers, but quite very active, about 30,000 lawyers. Right? And then I'm feeling like it's time to ratify. My question is, how long to the roadmap? With Amy, how long? How do you push this to the government to ratify? We would help you. Okay, Thai lawyers would help you. We can't wait. This is very useful. It's for the benefit of our nation and internationally and for what? Trade and investment policy spotlight. You see challenges and opportunities ahead. Now we have the light. It's come to light. So thank you very much. My question is, please, how long? To the vote now. How we go to the government and say, hey, we want to ratify in this government. How we do that? So thank you very much. So thank you.
Can we take one more question? The time is up or anything? Sorry, the time is up, so, but you can ask questions later. So,
I would like to clear on a little bit on because Singapore is the most powerful now because the point is that from the World Competitiveness Index, Singaporean takes consecutive years of the top ranking. This year is the second one, but last year the first one, and consecutive for 5 almost years. So I find that it's better that if we try to learn from the best practice and we follow that step, and we trust first. If we trust and we follow the planning and the policy, that leads us to the scope of working, and we go on the right way, and we can follow that. Why Singapore get the top ranking of competitiveness? Because rule of law is number one in that criterion. So Singaporean got the rule of law, the number one in the criterion. So that we should follow the rule of law. And the rule of law bring the people to economic growth. That is the number that proves them to be the richest country now. So thank you for, I would like to support that.
thank you very much. So the time is up. Let me close by thanking our panelists for their thoughtful insights. So we hope that today you leave with some answers. So thank you very much. Enjoy your lunch.
Big round of applause for the panelists. Thank you for coming. So we have lunch now. It's on the 7th floor. Please join us for lunch. Pick up your tickets, lunch tickets just outside the room here as you exit. And we're back here again at 1:30 p.m. sharp to start the third session.